You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. The Florida Supreme Court is now in session. All who have cause to plead, draw near. Give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case we have today is Wyatt versus the state of Florida.
We got two of them.
Yes, that is 08-655.
Your Honor, I believe on the docketing schedule that 656 was scheduled to be first, but we can go whichever way the court would prefer.
We thought this is the Domino's Pizza.
Reading from this docket.
Well, are you more comfortable with starting with, are you ready to start on 656?
I was ready to start on 656 simply because that's what the website said, but I can start on 655 if the court would prefer that.
Why don't you proceed with, describe the case you're going with, 656.
656.
There's a docket that is provided. It's out there. It's something that you really should consult before you come in here. But you can proceed
I'll proceed with 655, Your Honor, if we prefer. I want to, in any event, both of the cases have similar issues, though they're not the same, I would stress. But 655 and 656 both have the issue of comparative bullet-led analysis, which I would like to address first of all, Your Honor. In these cases, Agent John Riley from the FBI testified that he could match bullets found in the victims of both the Domino's and the other case with bullets held in Mr. Wyatt's possession. And this court relinquished jurisdiction to the lower court on account of a letter that was received by Ryan Butler, the state attorney in this case, from the FBI, suggesting that the testimony exceeded the science relating to the comparative bullet-led analysis. And this court last year relinquished this case back for an evidentiary hearing on that issue, amongst other issues. And I'd like to address that issue first, if I may.
And what I would suggest you do is assume that it constitutes newly discovered evidence, that is, the letter that was received specifically regarding the Wyatt cases. I'd like you to address the second prong of Jones and do it with respect to this case, of course, at this point, and then the other case. In other words, let's assume that the bullet analysis is now called into question. How can you establish that it would probably produce an acquittal of Mr. Wyatt for these murders?
Well, I think there's several things that we can look at in the record of the previous evidentiary hearing, Your Honor. First of all, the prosecutor in both cases, David Morgan, said that this testimony was extremely relevant to the case. I mean, it was there. It was testified to. This is the FBI. This is not the Indian River County Sheriff's Office, Your Honor. It's the FBI, who is probably the best known law enforcement agency in the Western world. It's cloaked in hyper-credibility. I think that given that situation, I think the jury probably would have given a great deal more credence and weight to the testimony of an FBI agent than perhaps to just a regular
But I thought that the CBLA evidence would link the victim's bullets to Wyatt. This is now in the Domino pieces murders, but it doesn't indicate who purchased the bullets or who fired the weapon. And we have a co-defendant here. But on the other hand, and you tell me if this has been called into question, as to the Domino Pizzas murder, the DNA, Mr. Wyatt's DNA, was found inside one of the victims. He admitted to stealing the Cadillac, which was less than a mile from the murders. He made inculpatory statements, and he possessed the .38 caliber pistol. Plus, of course, and I know you're going to attack it separately, but you have the testimony of Mr. McCombs. So you may want to do a cumulative on that, but if we accept what the trial court found, which that Mr. McCombs did not recant, his testimony is not called into question, then we have Mr. McCombs' testimony in addition to the DNA evidence that I mentioned, as well as to the admissions he made.
Yeah, I mean, the CBLA evidence is the piece that links Mr. Wyatt to the shooting, I would say. Yeah.
Well, how does it, again, does it show who had fired the weapon?
No, it does not.
So, in other words, to me, the most compelling evidence that links him to the crime scene and to the crime is his DNA found inside of the victim, one of the victims. There is nothing about, got the lights back, there's nothing about the DNA that has been called into question, is there?
Not by the CBLA, no, Your Honor.
Or by anything that you, so tell me, I find that very compelling evidence. How does that not place him at the scene committing the sexual battery, and therefore being, whether he's the shooter or a equal participant, he's still there?
He's still there, Your Honor, but I think we have to look at other factors that we brought up, including, that the evidence relating to McCombs, not only the statements made by Rollins and Morrison at the 2007 evidentiary hearing by perpetuation of testimony, but also the Amelia Bravo affidavit.
Okay, but now you're, and I understand you have a cumulative analysis. If you can state that evidence that McCombs recanted is credible, but we've got an evidentiary hearing. We have a trial judge who entered a lengthy order that found that McCombs not only didn't recant, but he reaffirmed that he had details that only could be supplied by Mr. Wyatt. They wouldn't be generally known. The other witnesses gave something about that he talked about the murder weapon. Well, in this case, the Domino's Pizza case, the murder weapon wasn't found. So it's not even consistent. So again, I ask you, assuming, first of all, that McCombs' testimony is still there, how does just the CBLA evidence lead to the probability of an acquittal?
Again, Your Honor, perhaps I should back up from the newly discovered evidence argument, although obviously said it in the alternative as newly discovered evidence and as Giglio-Brady matter. I think when we look at the testimony from the evidentiary, particularly relating to the testimony from Professor Spiegelman and Mr. Tobin, it's very clear that the FBI knew at the time that there was no scientific basis for this particular sort of assertion that a single bullet in a victim could be tied and held to be identical with bullets in a box, and therefore it came from a particular box. I think if you look at the testimony of Professor Spiegelman particularly, he was very clear that there had never been any meaningful or comprehensive scientific study on the part of the FBI that would have ever supported that kind of testimony.
But at the time of this trial, did we have any evidence that was called into question at that time? Not at this evidentiary hearing, but at the time that this trial took place.
Yes, we do, Your Honor. We have the testimony of Mr. Tobin, who had been involved with the FBI crime lab for a very long time as a metallurgist. And he testified in the second evidentiary hearing about the feeling of a metallurgist called Victor Gunn, who had was essentially what he described as the grandfather of this method. And he had apparently receded from this method and was trying to tell the FBI for a very long time that this had not been scientifically tested.
Oh, but there now what we go into. Are you now saying that the state of Florida knowingly presented false testimony?
Knowingly or negligently, Your Honor.
Excuse me?
Knowingly or negligently.
Well, so Giglio can't be established because there's no evidence that they knew that they were presenting false evidence. Not a scintilla of evidence on that. Because you made a point to say this wasn't the Indian River County Sheriff's Office, this was the FBI.
Sure, but it's still a law enforcement agency.
Well, I don't know of any case, and I know we've extended Brady to favorable evidence that's within the governmental entity, but that would take something that, again, I'm not sure the federal government knew, but something the FBI may have known and imputed that to the state of Florida. Where is that case?
If there isn't a case, there ought to be, Your Honor. I mean,
well, I don't, again, I understand that Brady, again, I can accept that there is an imputation between all of the, the prosecutor and anyone acting on the prosecutor's behalf, the investigative team. But the FBI is not part of the investigative team. And in addition, as Justice Quinn said, I don't think you've established that anybody in the FBI at that time knew that this was questionable evidence. I mean, it's certainly a rude awakening that when we hear scientific evidence and we think it's, because the FBI says it, we give it a stamp of approval. I can agree that this is it's unfortunate, but I also am glad that the FBI was able to come, and be forthright about it, so that we can bring this into, in a new lens. But I don't see where the Brady or Giglio claim is.
Your Honor, the Brady particularly, the FBI testified in this case that it was the basis of scientific research. It had to have known that it wasn't. There was no scientific research.
I don't know that Brady has to do with what somebody negligently might have, maybe if they looked, should have known. It's the idea of Brady, last time I looked, was that the state withholds either negligently or intentionally something that might be favorable. Well, that the fact that it's not scientifically available, scientifically verifiable, isn't anything that they had studied. It's not like they suppressed a study that said, don't do this because it's not scientifically reliable.
But they gave the impression, Your Honor, that it had been scientifically supported, which it hadn't been. I mean, science involves forming a hypothesis, testing that hypothesis, doing controlled experimentation, statistically validating it, peer reviewing it, and publishing it.
So you're saying
None of that had ever happened.
So you're saying it should have been Fry tested?
Yes, Your Honor.
Well, who would be responsible for Fry testing it? Asking for Fry testing, the lawyer?
Yes, Your Honor.
Okay, and what did the judge find about the lawyer's performance in this case, in that regard?
That it was not deficient, Your Honor.
And
didn't he, in fact, get an expert to look at this?
He got an expert, but it didn't go very far in this particular case, Your Honor.
I'm sorry, if you would speak.
I'm sorry. He did get an expert, but the expert wasn't. None of this came to light from the FBI, which is very much cloaked in secrecy, until later.
And that's why as I said, we started out, I think you have a good newly discovered evidence claim. I don't agree that at least I don't agree that it's procedurally barred, but I think your problem is the second prong, whether it would probably produce an acquittal. Certainly in a case where it's the critical piece of evidence, that's going to be a different story. I don't see in this case, and it may, we can discuss the Neidiger case separately, how this was the critical piece of evidence if it doesn't link him to being the shooter, and we know he was there.
Yes, Your Honor. I would say I would come back to the cumulative analysis. It is one thing, like I said, Patrick McCombs. is not the most credible of witnesses, even back at trial before we knew.
How
Well,
could,
but the post-conviction court decided to the contrary, didn't it? I mean, I understand your view about the credibility, but ultimately, unless there's not competent substantial evidence to support the trial court and the post-conviction court here, we are bound by the factual determinations, including the credibility determinations of the post-conviction court. Isn't that what the law is?
I would put it a little bit differently, Your Honor. The court has to undergo an analysis under Porter, which is not really part of this case. But that being the case, I think the comparative bullet-led analysis is important in this case. It was referred to in closing argument in the Domino's case as putting the bullet as being identical to those in Mr. Wyatt's possession. And as I said, the enhanced credibility of bringing somebody down all the way from Washington, D.C. into the middle of Florida to do this kind of thing.
I understand that maybe this is the best you can do, but I just cannot fathom how this is relevant in light of the DNA evidence, which you're not contesting, which establishes that he was there and committed a sexual crime against one of the victims.
And that hasn't been contested in this brief, Your Honor. But
let me just go back on McCombs, because we always do, or at least, there's been concern from time to time about what we call the jailhouse snitches, or some people call jailhouse snitches.
Yes, Your Honor.
But this, and certainly if McCombs recanted his testimony or was found to have lied, that would be very serious in this case, because his testimony does establish HAC. I mean, it's very graphic. How else, other than from Mr. Wyatt, can Mr. McCombs have obtained the detail that he obtained? You had Bravo, but they never established that Lovett was in the same place as Bravo. So is there anything other than mere speculation as to how Mr. McCombs could have obtained this detailed description of the crime?
He could have made it up. It's,
But it was collaborated at every point independently.
not some of the things that, the remark about the listen very carefully, that could only, that was pure McCombs. It couldn't have come from anybody else. McCombs' testimony supported a lot of aggravating circumstances, not just HAC.
No question about that, but it's not. But back to what the trial court found, the trial court didn't find that that his credibility had been impeached to the extent that it would change the outcome. And that's what I'm asking you. What, and you mentioned these two inmates. Well, there's some crazy things that go on, I guess, in the federal protection system where they're all trying to vie for better places to stay, but nothing they said would even remotely relate to something that McCombs would have told them. So I think that evaluation, their credibility, was also done.
Well, I think we have to look not only at the live witnesses, but also McCombs' voluminous writings and his continuing relationship with the state attorney's office in Vero Beach.
But except that, again, there is no evidence, and both the prosecutor testified to this, of any other agreement other than what was, explained at trial.
But again, after trial, the prosecutor Morgan did write to the assistant U.S. attorney who was dealing with McCombs, and pursuant to Federal Rule of Criminal Procedure 35, asked for some treatment to be some favorable treatment to be granted to McCombs, which in fact happened. He was given a 20-month reduction in his sentence.
How long? What is his sentence?
I don't remember exactly what his sentence was.
Pretty lengthy sentence.
It was a lengthy sentence.
Not like he was all of a sudden going to go from being incarcerated for years to being out.
It was a 20-month, which is nearly 2 years. he was given consideration, and he was put in the witness protection program. So, I mean, he was given some favors for his testimony, yes. So there is that. And the timeline, I mean, Mr. Morgan's letter to the assistant U.S. attorney happened just weeks after the Domino's trial. So the timeline is very interesting. If I may turn to the penalty phase of this particular case.
You're way into your rebuttal time. You just need to be aware of that. You're welcome to keep going, but you're using
I'll
your
reserve the
rebuttal
remainder of my time. Thank you, Your Honor.
Good morning. May it please the court. Lisa Marie Lerner with the Attorney General's Office. On the comparative bullet lead analysis, as the court pointed out previously, Mr. Wyatt cannot meet the second phase of the Jones test, as this testimony at the original trial was actually an ancillary issue. It did not point to Wyatt as being the shooter, and in fact, Wyatt testified at this trial and admitted that he possessed the bullets and the guns, but that he was in the bar and that Lovett took them and used them.
I think we're in the wrong case. We're starting with the Domino's Pizza
Right.
case.
Right.
The bar case is Neidiger.
No, yes, but-
I'm confused, or are you confused?
no. They went to many bars. In the Domino's case,
Okay, and I'm
Wyatt-
confused. But I thought it was which bar? But
Marvin Gardens bar.
Okay, so this is the case though that he waived his penalty phase, correct?
That is correct.
Okay, and he testified on his own behalf in both cases?
Yes.
Okay, so tell me what he's testified in this case.
He admitted to possessing 2 guns, including a .38 and the ammunition. So even though the state decided to put on this evidence, it was an ancillary issue.
But what was the point of the evidence? I mean, if in fact the evidence doesn't really connect Mr. Wyatt, then what was the state trying to get by putting on this evidence?
Well, it did connect Mr. Wyatt with the ammunition. The comparative bullet lead analysis did 2 things. One, there was a chemical analysis of the bullets to say, they were so much lead, so much chrome, I'm making this up, and some other metal, and that the bullet in the bag had the same chemical composition as the bullets left at the scene. That was.
And is that still in question, or has that been called into question?
No, that is
portion of it?
still excellent science. And the testimony at the evidentiary hearing said that that's still good science. The problem came with the statistical analysis applied to that science, saying that they could definitively match up, an individual bullet with a manufacturing time and box. And that's what was thrown out. But, so Wyatt admitted to having the bullets. It was an ancillary issue.
But then they never found the gun?
No, they never found
They
the
never
gun.
found the gun. Did they or did they not find actual ammunition on Wyatt or in his possession?
Well, they found it on Freddie Fox, and Freddie Fox testified that Wyatt handed him a gun and ammunition. Also, there was testimony from the owner of the Cadillac that he had a .38 Smith & Wesson in the car at the time it was stolen. They never found the murder weapon for the Domino's case. However, there was testimony, which was uncontroverted, that the bullets from the 3 victims came from most likely a Smith & Wesson .38, given the very unique rifling marks that a Smith & Wesson makes on bullets, that other manufacturers do not make the same rifling marks. So you have Wyatt in a Cadillac with a .38 Smith & Wesson. There was testimony that a Smith & Wesson was used to kill these people. The same type of bullets was found with Wyatt. His sperm was found in the woman in a 1 in 32 billion chance that it was Wyatt.
That's sort of, once you get there, I mean, that's to me the thing you start with is the state, because that is devastating evidence that puts him at the crime, having committed the crime, one of the crimes, and then the only question is, I mean, was there a question of actually who shot the victims? Because both the co-defendants both initially got death, correct?
That's correct.
Was there an issue as to who was the shooter?
According to Wyatt, there was. Lovett, if this court remembers, turned himself in and confessed and consistently said that Wyatt was the shooter. And this court, in Lovett's direct appeal, made a factual determination that Wyatt was the shooter.
How did we do that? That wouldn't be binding on.
No, I'm just answering.
I don't think the court on appeal makes a factual determination of who's the shooter.
But be that as it may.
Was there some testimony that Wyatt was up front someplace, either drinking or eating something, or was he in the same place where the shooting took place, or was he someplace away from that? Not Wyatt, but Lovett. I'm sorry.
McCombs testified that Wyatt told him that Lovett was up front.
Right, okay.
And because Lovett was the one wearing the Domino shirt, in case anyone looked in, he would look like an employee. And when they found the Domino shirt, they found Lovett's hair on it. Granted, hair analysis is not unique, but Lovett's hair and Wyatt's hair were very different. And additionally,
that's why I was wondering. So this did occur in the Domino's Pizza. That's why I was wondering when you were talking about drinking in a bar.
That was Wyatt's testimony, that he was not at Domino's at all.
Okay, so really, again, the DNA just refutes that 100%.
Right. And on cross-examination, he just said the DNA evidence was wrong. He had no explanation for that. So the state contends that Wyatt cannot meet the second prong of Jones, that it would result in an acquittal. On McCombs, again, this was not a recantation because McCombs reasserted what he testified to when the state contacted him after they found out about Rollins and Morrison. He came into court in 2007 at the evidentiary hearing and testified that his trial testimony was accurate.
Well, I realize he did that, but could you explain, as I was trying to understand, what did the state establish, if anything, was the motive of these two other inmates in the federal prison to make up something about Coombs? Is there something about the whole, and these were all where snitches go and they all then keep on snitching or something?
Apparently this is a particularly bad unit. There was testimony that Rollins met McCombs in 1989 or 1990 when they were both in federal custody. And Rollins read media accounts of the Wyatt trial, and so Rollins knew something about the trial. And McCombs and Rollins apparently had a falling out. There was testimony from Morrison that there was really bad blood between Rollins and McCombs also testified that Rollins kept trying to get McCombs in trouble and cause him problems. So that's the genesis of that. Also, Rollins in his videotape testimony admitted that he was just, when he wrote both the prison warden and then he wrote the state attorney directly saying that that McCombs was significantly untruthful. He did not bother to contact Wyatt's defense attorney at all. And when questioned on cross-examination, Rollins said, well, he was just, playing around with the system and trying to get someone from Florida to come up and visit him, and he essentially admitted to just manipulating the system.
McCombs also was trying to manipulate the system.
Yes.
There's no question about that. But how is the state able to say, and I just want to make sure, because you would agree that if McCombs' testimony was found to be unreliable, the penalty phase in this case is seriously called into question, especially the HAC.
McCombs knew...
Do you agree? Does the state agree with that? That the McCombs, the terrible details about how the husband had to watch as the wife was undressed and raped, and all of that comes from what McCombs says, correct?
That is correct, Your Honor. However, McCombs knew a number of facts that were not in any media report at the time and were not contained in the extradition papers. Judge Morgan testified to that at the evidentiary hearing in 2007. He also testified that the police and the state did not send any police reports or case materials to Wyatt while he was in North Carolina. McCombs talked to Wyatt when he was in North Carolina, not in Florida. So the only papers that Wyatt had was the extradition request written and submitted by Judge Morgan. And Judge Morgan testified about what that had in it. McCombs knew that Wyatt and Lovett went into the Domino's Pizza shortly after 11 and ordered a pizza. There was testimony at the trial that someone called in at 11 from outside, ordered a pizza. That call was taken and it was logged in on the register at 11:01. And the person who called in testified at trial. The next order was at 11:06, and that was a in-store order that was testified to at trial. There was not a receipt, but the cash register record showed that at 11:06 someone ordered a pizza. There were other witnesses who testified coming and going. So this crime happened between 11:06 and 11:30, roughly. McCombs knew that they ordered a pizza. That's not something that would be in newspapers.
I mean, that's not exactly a, this is a Domino's pizza place,
Yes,
so.
but I have a
it would
whole
be
list. I'm going to go down my list.
Okay.
That's not the strongest part.
I try and work up my way up.
Start with the strongest, so.
McCombs also knew...
But you're saying the time frame was
Right.
is significant.
Right. McCombs also knew that Wyatt had pistol whipped the manager to get into the safe, and that was not in any of the documents. He also,
And is there evidence that he was pistol whipped? Is that?
Yes.
Okay.
He also knew that Wyatt only got $1,000 from the Domino's Pizza, and the amount of the robbery was not in any of the papers. At the trial, the Domino's general manager testified that approximately $1,200 was taken. So McCombs was accurate on the amount of money that Wyatt got. He knew that Lovett wore a Domino shirt and that it was discarded by the car. He also knew that Wyatt got a ride at some point from a cabbie named Fast Eddie. The state brought in someone, Eddie Pugh, whose nickname was Fast Eddie, to testify that he picked Wyatt and Lovett up.
Just a question as you're going through these. What was, tell me again, where it was that Wyatt and McCombs were in jail together and for how long? Because this kind of evidence is the fact they say, that they actually talk about the time of the murder and these details does seem a little strange. Usually someone might, if they're going to talk, they might talk about the details of the murder or say some things, but this is unusually detailed.
Well, McCombs testified that they had over 30 conversations, and they were, right next to each other. They were incarcerated in North Carolina. McCombs was in there on his own charge, and Wyatt had been picked up after he was caught driving the stolen truck from his employer. And McCombs talked to Wyatt while Wyatt was in custody up there approximately 2 months. It was over about a 2-month period while Wyatt was waiting extradition.
And when was the first time that McCombs told any authority about these conversations?
Within a couple months of these conversations.
So he waited, did he take notes?
No.
So he had 30 conversations over 2 months, and then he waited another 2 months?
I'm not exactly sure, but he notified, he talked to his father and decided he was going to notify, and he wrote a letter to the state attorney in Florida. Shortly.
Yeah, other
after.
details that he would have known from McCombs?
He knew about Fast Eddie, and also significantly, he knew that Wyatt used 2 different kinds of bullets. And
I believe McComb was in South Carolina, not North Carolina at the time.
I could be wrong.
Yeah, you are.
Is there any suggestion in this record at all that McComb was in Florida at the time of this murder?
No.
Okay.
And nothing that McCombs, I mean, this would be the other critical thing, ever shared a jail cell or was incarcerated at the same time as Lovett?
There was no evidence put on at the evidentiary hearing that McCombs and Lovett even knew each other, were housed in any unit at the same time.
And the state carefully looked at that, because I would assume before the state's going to put something like this on, they're going to want to make sure this is viable testimony as it can be.
I would assume so, but
We don't know anything about
I
what
didn't
this-
speak to the state attorneys. However, this issue was brought up at the 2007 and 2009 evidentiary hearings, especially the 2009 with Mr. Bravo's affidavit. But neither side, Wyatt or the state, could produce any evidence showing that Lovett and McCombs were ever housed together.
Did according to McCombs, did Lovett participate in these murders?
According to McCombs, Lovett was there and was participating in the robbery, but and pulled a gun and whatnot. But McCombs said that Wyatt admitted to being the shooter.
Any other? That's pretty important. Any other? What did he? And he gave the details of the sexual battery.
That's interesting. There are 2 things McCombs knew nothing about, and he did not testify to them at trial. He knew nothing about the sexual battery, which was in the newspapers, and he knew nothing about the Cadillac being burned and abandoned, which was in the newspapers.
I thought, now make sure, that wasn't their testimony, because when I asked you about the HAC, I think you said, yeah, that's what part of the HAC. But I thought that his testimony, Coombs, I thought that there was testimony, at least we recited it in the direct appeal, about the husband watching as the sexual battery took place.
I recall that.
Who would have testified to that?
McCombs. And McCombs also, I'm sorry. I think that was the state argument. I don't believe there was any testimony directly about the husband being present during the rape. I think that...
We put that in the direct appeal even though there was no evidence of that?
McCombs did not testify about the sexual battery. What McCombs did testify to was Wyatt making a statement to Barnouche about listening to the wind as the bullet entered his ear.
Let me just make sure that this, in our direct appeal, said, next Wyatt argues the trial court erred in finding the murders to have been especially heinous, atrocious, or cruel. We cannot agree. The evidence shows the victims were subjected to at least 20 minutes of abuse prior to their deaths. And they talk about the pistol whip. That's what you said he testified to. And it says, dressed Francis Edwards completely, and raped her a short distance from where the other 2 employees were being held. Is that just based on
the physical evidence?
The physical evidence, okay. Here's Edwards begged for his life. That's from, is that from McCombs?
That's from McCombs, yes.
Okay, and stated that he and Francis' wife had a 2-year-old daughter at home.
That's from...
Okay, so you're, upon seeing her husband shot, Francis Edwards began to cry. That's also...
McCombs.
So, interestingly, so the only detail that Wyatt left out is anything about the sexual battery?
And burning the car. And in terms of the penalty phase evidence, the defense attorney did a lot of investigation and was prepared to put on 12 witnesses. And the state would ask the court to rely on my brief and the arguments in there. We ask you to affirm.
Let me come back to the penalty phase, Your Honor. Trial counsel relied heavily on an investigative report from a North Carolina state investigator, and without doing any further investigation into the witnesses that that state investigator talked to, in particular Mr. Wyatt's ex-wife and one of his school teachers, Sarah Cox, she decided not to talk to these people and did not do the social history that would have come from these people.
Now, this one, though, involves a waiver of mitigation. So what do you have to establish in order to establish that they were ineffective? I mean, they actually went and got an investigator, did as far as I can see, a very thorough social history, and even though he had consistently told him he didn't want to put on mitigation in this case. So are you saying that if he had known about these two witnesses, he would have said, oh, everything I've said for the last X number of months, I really do want to put mitigation on?
I think he wasn't aware of mitigation that could have been put on because it wasn't investigated fully. I mean, what the record shows is that Mr. Wyatt did not, he asked his counsel to ask for a continuance of the penalty phase.
Well, that's when he, at the point the night before, when he finally decided he wanted to put on his mother and sister or something.
Yes, Your Honor, and they were unavailable due to medical reasons. He felt that this
wasn't there a change of mind the day before?
He had been vacillating, but the point of the matter being that in cases such as Blanco and a number of other cases, are very firmly for the proposition that you can't waive mitigation knowingly without knowing what the mitigation is. And that's the situation that we have in this particular case. Trial counsel did not do the necessary diligent investigation that Wiggins versus Smith and the well-settled Supreme Court case law requires in this particular case.
You have exhausted your time. I'll give you another 30 seconds to sum up.
So in other words, Your Honor, I would ask this court to reverse and remand appropriately. Thank you.
We thank both of you. The court will now take a 10-minute recess.
Please rise. Florida Supreme Court is now in session. Please be seated.
We now turn to the second Wyatt case on our docket.
Morning again. I want to address two aspects of the brief in this particular case, Your Honour. First of all, I want to go back briefly to the CBLA issue as it relates to this particular case, not the Domino's case, but the Neidiger case. And after that, I would like to address the ineffective assistance of counsel.
Could you speak into the microphone, please?
I'm sorry, Mr. Wyatt's penalty phase. Regarding the comparative bullet-led analysis in this case, I think it's very clear that from the trial record, particularly the prosecutor's closing argument, that they relied very, very heavily on the CBLA testimony in the Neidiger case.
In this case, what additional evidence is there? Let's not go into the jailhouse snitch.
No.
What's the independent evidence here? Maybe a little less than the other case this morning.
Well, this case is a little bit, this case is the one where the comparative bullet-led analysis is really the key to establishing that Mr. Wyatt...
I understand. I accept that. Where's the other evidence, though? How do you view, other than the jailhouse snitch?
Well, he was certainly very important according to the prosecutor's testimony.
What's the rest of the evidence? We have them leaving together on the evening where the lady disappeared.
Yes, Your Honour, I mean...
Okay, what's the other evidence?
I wasn't planning to go into that.
Well, it's important analysis because
yes,
that's how you're going to get there with Jones, are you not? I mean, do you not need to do that? If you think you don't need to do that, then that's fine.
What I think I need to do is to go back and look at what the prosecutor said at the closing argument, which was that he spent about a page and a half tying in, through the CBLA testimony, this was the fact that these two people shot these two bullets, and what are these bullets? And he said, and what he said was, if it hadn't been them, that is to say Wyatt and Lovett, firing the gun, the bullet would have been different. In other words, he was predicating his position that these two fired that gun on the comparative bullet-led analysis. There's nothing else to show that that was the case. I mean, there's other things, obviously, that led to the conviction, but the firing of the gun. So it is a little bit qualitatively different.
What was, did Fox testify in this case?
I don't recall, Your Honor, I have to check
Well,
that.
I thought that Fred Fox, let me just make sure that I've got this right. What happened, didn't he made statements to Fred Fox, and I thought that Fred Fox pawned the gun or something?
Yes, John, I don't remember the details, I apologize.
Well, that could be, I mean, I guess the reason those details could be important because they link, if they link Wyatt with the gun, but and maybe the state can tell us on that, about that evidence. And I agree with you that in this case, it was the DNA of the co-defendant
Yes, Your
was
Honor.
found inside the victim. He does admit that he met Neidiger, and he says they all came back to his hotel room, correct? That's
Yes,
what
Your
he
Honor.
said.
That's-
But that he fell asleep, and then Neidiger was gone when he woke up. Is that what he says?
I believe in so many words, Your Honor.
But his hair is found inside of Neidiger's vehicle for
Yes.
hair analysis.
I believe so.
And he says, well, the vehicle was left there. Lovett said she left it for him to use, and he just used it and then abandoned it.
I believe that's the case, Your Honor.
Well, I mean, I'm a jury listening to that, and the statements, the inculpatory statements he made to the police, the fact that he was with her the night before, and the fact of, I believe that he is still linked to this gun through Fox. I could be wrong on that. To me, the fact of being able to establish a probability of an acquittal is a high burden. I don't see how you've got to establish without that evidence in a probability of an acquittal.
Yes, Your Honor. Again, I go back to, I'm not going to rehash what I said in the first argument, but...
Well, in the first argument, though,
was a different situation.
I would agree that there's qualitatively different evidence in this case. I think you might have a stronger case here than in the Domino's Pizza, because in Domino's Pizza, his DNA is found inside of the rape victim. Here, it's Lovett's DNA that's found inside of this victim.
Yes, Your Honor. Anyway, I stand on my brief on that particular point. I'd like to move to the penalty phase, ineffective assistance of counsel, Your Honor. In particular, the claim that trial counsel was ineffective for failing to properly investigate mental health mitigation in this case.
In this case, Wyatt did present mental health testimony.
He did not give any purported waiver in this case, Your Honor.
And it was investigated, and there were witnesses that were presented. And there was mental health experts who were consulted, and a strategic decision made not to put on the mental health experts. So tell me what's wrong with the judge's very, very comprehensive analysis of why there was no ineffective assistance.
I would take issue with the fact that a strategic decision was made to put on no mental health mitigation.
Isn't that what the defense attorney had those two experts?
She did have those two experts,
So
Your
what would
Honor.
be the other explanation, that you just forgot she had them?
No, Your Honor, the strategic decision was not a strategic decision because it was based on a less than full investigation, a less than proper investigation.
No, we're talking about the mental health experts.
Yes, Your Honor, exactly.
What else did you get mental health experts, and they perform a mental health investigation or evaluation, and then they supply it to you. What is the attorney supposed to do?
The attorney is supposed to supply information to the mental health to the mental health professional, which would assist with the determination of whatever mental mitigation there might be. I mean, this court has seen a number of instances in which a trial attorney consults a mental health professional. The mental health professional goes and conducts an interview with the client and forms an opinion, but without consulting any collateral information, school records, that kind of thing, talking to school teachers, family members, and the mental health professional gets absolutely torn to shreds on cross-examination, because the state will say, okay, this client, this defendant is trying to save his life. He's saying things to the mental health professional who cannot corroborate them with third-party information. That's what happened here. Now, what would happen? In that way, the failure to do a proper social history is very much linked to the failure to do a proper mental health evaluation.
Well, what should have been supplied that wasn't?
Information relating to Mr. Wyatt's childhood trauma, his history of abuse at the hands of his family, the fact that he was consuming alcohol from a very young childhood age, the fact that his mother herself was mentally ill, she was schizophrenic. All of these things should have been factored in to his mental health evaluation.
I guess the judge, I'm somewhat influenced by the judge's very detailed evaluation of this claim, which is, of course, it's very helpful to us when we have this. And is this not true that there was a host of very unfavorable evidence that would have come out? Now, I understand sometimes you kind of weigh and say what's bad, but they didn't find evidence of brain damage, and your new witness finds some mild impairment. He had a notorious and infamous reputation for being aggressive starting in middle school. He was involved in all kinds of criminal activities. He was physically abusive towards his wife. He beat a person for at least 30 minutes and locked him in a trunk. He demonstrated bias toward homosexual advances. He had been locked up since he was a juvenile. He has shown great entrepreneurship and ingenuity manipulating the system. His nickname in prison was Killer for his willingness to fight. And I could go on and on. I mean, I understand sometimes you try to say, well, how bad is it? This is pretty bad. I mean, I don't see how an attorney faced with all of that bad stuff could be faulted for deciding to put on cooperative lay witnesses in this case.
Well, again, I think the court needs to look at the case law. I think it was Williams versus Taylor that made very clear that, yes, sometimes bad stuff comes out of an investigation quite frequently in these cases, but you don't stop your investigation just because bad stuff comes out. You have to have a complete picture that you can feed to your mental health professional. And if in that case the mental health professional says, I can't help you, then that's
did
different.
Dr. Rifkin not know about the mother's mental illness?
He may have known peripherally. I don't believe he spoke with her. I don't believe he spoke with school teachers. I don't believe he spoke with family friends. I don't believe he spoke with other family members, Mr. Wyatt's ex-wife, like Dr. Sultan did, who testified in the evidentiary hearing.
Well, is there an obligation for, again, I agree with you that you want to make sure that counsel does a reasonable investigation to uncover records, school records, depending on what year it is in the death cases have progressed, but is the mental health expert charged with going out and doing his or her own investigation?
No, Your Honor. The mental health expert has to do whatever the mental health expert feels is appropriate to be able to form an opinion to the best of their ability, given what their discipline is within mental health. What I'm saying is, first of all, if trial counsel had done a proper social history, as mandated by Wiggins and the other line of cases from the Florida Supreme Court, from the United States Supreme Court, then there would have been a much more compelling psychological explanation of both the good and the bad things that happened in Mr. Wyatt's early
Let's
life.
look at the prejudice prong for a moment. And I have to say that I guess I really thought, I think you have a hard time of showing the deficiency, but on the prejudice, what was by the time that this trial came up, he already been convicted of the Domino's Pizza murder?
Yes.
Second trial. So what was the aggravation found in this case?
Well, the prior violent felonies, obviously, Your Honor, and under sentence of imprisonment, avoiding arrest. There weren't as many as there were. CCP was found, but then reversed by this court on direct appeal.
I guess what I'm trying to find out is, do you think, or can you tell us how the assessment of mitigation, where they would have said, and how old was Wyatt at the time this happened?
At the time of the crime, 24, Your Honor.
How his social history would have changed the mix so it would undermine our confidence in the outcome. Would it establish a statutory mental mitigator? Did Dr. Sultan testify to that?
She testified to a plethora of non-statutory mental health mitigations, Your Honor.
I guess the answer is no, she didn't establish a statutory mental mitigator.
No, Your Honor, she did not. But I would like to turn also to the social history as it reflects on Dr. Bordini, who is the neuropsychologist who was retained at the 2007 evidentiary hearing. Dr. Bordini did neuropsychological testing and found that Mr. Wyatt does have frontal lobe dysfunction. Now, this is something that should have been looked at the time of trial and could have been looked at if trial counsel had done the social history, because all the indicators were there from his childhood, particularly his heavy childhood consumption of alcohol from a very, very young age, and also his physical abuse, both the emotional and physical trauma that he underwent from his father and during his childhood. Those sort of factors, had they been investigated, should have led trial counsel to investigate the possibility of brain damage further than they did. I mean, just hiring a psychologist, Dr. Rifkin, who does a very cursory evaluation without going into the family background, is not in and of itself helpful, because he's relying solely on his impression of the person in front of him.
Just going back to something that Justice Polston asked, the judge in her order said, Wyatt points to no specific mitigation document that defense counsel failed to obtain and deliver to Dr. Rifkin and or Dr. McMillan, or that counsel failed to review for the penalty phase. Is that an incorrect statement?
Documentation. I don't believe school records were supplied.
So in other words, that's wrong, that conclusion of fact by the trial judge is erroneous?
No, I don't believe that school records were located at any point. Whether they could have been located at the time of Mr. Wyatt's trial in 1991, I'm not sure. However,
but that's a pretty, you know, if we ask, and I realize you've got two cases back to back, and these are factually intense, but if you're going to tell us that they failed to do something, we got to know that there was a record that was right there or should have been there. Talk about these Wiggins and Williams, and we're familiar with that. That the lawyers failed to uncover something that would have changed the whole mix of the mental picture.
I'm not putting it very well, Your Honor, clearly. What I'm saying is that there were individuals, particularly the school teacher, Sarah Cox, who trial counsel could have talked to. But trial counsel read a very cursory report from North Carolina and decided she wasn't going to go any further with Sarah Cox. And in fact, Sarah Cox had a great deal that was useful to say in terms of the social history, which shed light on his early life, which in turn would have been able to shed light on his mental health mitigation. That's what I'm trying to say to you, Your Honor. I don't know if I can put it in any other word. But I do believe that the social history that Dr. Sultan was able to elicit through speaking not only to Mr. Wyatt, but also multiple other witnesses, was the sort of thing that trial counsel could have done and arguably should have done in order to throw light on Mr. Wyatt's early life and be able to show not only, the good things and the bad things that happened to him, and admittedly there were some bad things, but put them in a context as to how he got to the place where he
But it seems
was.
like that is the quintessential Monday morning quarterback in this regard. If nobody is going to be able to say that this crime itself was the product of some extreme emotional distress or other mental illness, then you really risk the idea that the whole history of this defendant is just bad stuff. It's more bad stuff. They're already going to get the bad stuff from Domino's, and the idea that they'd think that this guy is just, it'd be like saying Danny Rawlings, well, he had this or that. At some point, it almost doesn't matter. The aggravation is so significant that it pales in comparison to any mitigation. And this seems like that case.
Well, the United States Supreme Court has made it very clear that there does not have to be a nexus between the mitigation, the mental health mitigation,
I know
and the
it
crime
doesn't
itself.
have to be, but for it to undermine our confidence in the outcome, that is that we would think a jury faced with this might reach a different conclusion, it's got to be pretty compelling.
Well, at least one juror voted for life in this particular case, unlike the Domino's case. So there is a strong possibility that other jurors might have done, given the more compelling investigation and presentation. Your Honor, I believe my light is on. Am I into rebuttal?
You're in your rebuttal time.
Okay. In that case, Your Honor, if the court has no further questions, I'll reserve the remainder of my time.
May it please the court, Lisa Marie Lerner with the Attorney General's Office again for the state. On the first issue, the comparative bullet-led analysis, just briefly, again, this issue was not contested at trial. It was not part of the defense strategy to attack this evidence by trying to keep it out.
Well, again, is that really, you've got the FBI saying it's science, and so I don't know, the fact that it wasn't contested, is it true that the closing argument of the prosecutor relied on it fairly heavily?
Well, the prosecutor did rely on it. I don't know if it was heavily. He had a lot of other facts.
Well, let's go to the other facts, because this case, unlike the Domino's Pizza murders, doesn't have his, quote, fingerprint in the form of DNA in the victim. In fact, it has Lovett's DNA. And so tell us all the compelling evidence that shows that even if this came out, there would not be a probability of an acquittal.
First of all, this evidence does not establish him as the shooter. The bartender at the bar testified that she knew Ms. Neidiger, and she saw Ms. Neidiger leaving the bar with Wyatt alone. They were gone for about an hour, and then Wyatt came back in her car by himself. That was testimony from the bartender. There's testimony that Freddie Fox saw Wyatt driving Ms. Neidiger's car after the day after. A pillow from the motel room where Wyatt was staying was found.
Before you go further, I thought that the evidence was, you said that Wyatt left the bar with Miss Neidiger alone. I thought the three of them, that is, that Wyatt, Neidiger, and Lovett all left the bar together and went to Wyatt's hotel room.
I believe, and I can look it up, I hope, while I'm arguing, that the bartender testified that Wyatt and Ms. Neidiger left alone.
I have, and the trio spent much of the night together drinking, playing pool, and playing this crane game. Wyatt and Neidiger disappeared for about 15 minutes. Wyatt reappeared, talked to Lovett, and all three left for the evening. Now, that is from either our, it's from the transcript of the testimony, and I'm assuming that's from the testimony of the bartender. So I don't think what Justice Quince is asking is pretty important, because if obviously he left with Neidiger for an hour and came back in her car alone, we've got a very strong, much stronger case. But if they only disappeared for 15 minutes and the three left together, then it's weaker.
I believe that bit of evidence came from Wyatt. Wyatt again testified in this trial. And this is according to my notes. I don't have the transcript in front of me. But in Volume 5, page 736 to 38, Ms. Oler, the bartender, testified that Kathy hung out with Wyatt at the bar. They were playing the crane game, they won animals, and she saw Ms. Neidiger and Wyatt leave the bar with toys, and she didn't see Kathy again after. Wyatt returned within 15 minutes, went and got Lovett, and left.
Okay, 15 minutes. So is the idea that in the 15 minutes is when he killed Neidiger?
I'm not sure.
I mean, that I guess is there any evidence of where she was killed?
Oh, yes.
Where was she killed?
Out off of State Road 60.
And where was the bar from State Road 60?
It was approximately, I believe, if my memory is correct, 3.5 miles away.
So is it, again, I guess we got to, because we've got that exact transcript. I thought that, and so when, under that theory, would Lovett have had the chance, if she was killed in that 15 minutes, would Lovett have had the chance to have had a sexual encounter with her?
I don't know, Your Honor. So
Well,
it is.
Well, who testified in this whole scenario? I thought they left the bar and went to some hotel room.
That was Mr. Wyatt who testified.
That's just Mr. Wyatt's testimony. There's no other evidence to support that they all left the bar and went someplace else.
No.
I thought, again, Wyatt reappeared, talked to Lovett, and all three left for the evening. That's at transcript page 738 of Volume 5.
Right. Mine, again, I'm just relying on my notes. I don't have the transcript. She saw Ms. Neidiger leave with Wyatt, and she never saw Ms. Neidiger again. Wyatt came back, got Lovett, and then those two left.
Okay, now let's go back to the Fred Fox testimony. He saw him, Wyatt, driving Neidiger's car the next day,
Yes.
and we know that the hair was at least consistent with Wyatt's found in the car. But isn't there what about linking him with the gun that killed Neidiger?
There's a couple other additional pieces of evidence. Mr. Fox was the one who had the bag of bullets and the Charter Arms pistol. And he testified that Wyatt was the one who gave him both the Charter Arms pistol and the bag of ammunition.
So in this case, the murder weapon was found?
They believe it was the Charter Arms pistol. Mr. Fox pawned it at a pawn shop and told the police he did so. The police went and got it from the pawn shop, did test firings with it. They said that it was consistent with the rifling marks found on the bullet of Neidiger, but they couldn't be 100% sure because the bullet was damaged.
Okay, so isn't this where then the CBLA testimony becomes much more critical? Because what is the, so we now have a gun that's traced to Wyatt, which is, because he gives the gun to Fox, and bullets, and it's
and
consistent.
the gun is the one that shot the bullet.
It's consistent.
It's consistent with the one that shot the bullet.
That has not been questioned.
No.
What part, though, does the comparative bullet lead analysis play in this case? What else was then testified to that was important to the state's case?
Well, the state put on that the chemical composition was the same as it did in Domino's, and then the statistical analysis.
No, but explain that the chemical composition of the bullet found at the scene, found in her?
Yes.
Was the same bullet as the bullet that were in the bag of bullets given to Fred Fox?
Was the same chemical composition, and then the FBI agent testified about it coming from a certain, production and box.
So they took it from something that would be helpful on that one. Doesn't that then become almost scientific certainty, at least in the eyes of the jury, that no matter what else Wyatt's saying, that this is like the fingerprint evidence of that this gun, may have been used to shoot the Neidiger, but now the CBLA showed at the time that it was like 100% certain it's the gun and the bullets that were used?
The FBI agent didn't say anything about the gun and didn't give...
the bullets.
And didn't give any percentages. And
what
also,
did he say?
He just said that it came from the same lot that the bullets in the bag did. But on cross-examination, the defense attorney essentially completely discredited his testimony. She got him to admit that he had no information on how many bullets had been produced. They could be billions. No information on where the boxes were sold or distributed, and she completely decimated his testimony on cross. I outline it in detail in my brief, and I'd ask the court if you want the details to incorporate my brief into my argument. I don't have them right in front of me, but she is completely neutralized his testimony on her cross-examination.
And the trial court went into that in her order.
I would like you to address the question that I posed to opposing counsel. Allow you the time to explain to us the evidence that you see absent that report or the FBI information that inculpates this particular defendant in this murder. I think that is critical in this case.
Yes. There was the bartender linking Wyatt with Neidiger.
Well, you've done that. I just want to make sure you go further with it, or have you completed it?
No, I haven't.
Okay.
There was the gun that Freddie Fox had, and finally, Wyatt was staying in a motel that had a pillow that was found at the crime scene, and there was testimony from the police officer and the motel people saying that it was consistent with being their pillow, and they had a unique way of putting two pillowcases and folding it in a special way, and the pillow found next to Ms. Neidiger was the same as the one in Wyatt's room. They couldn't say it's absolutely the pillow, but they said it's consistent.
Could you explain the geographical relationship between those two places? Where was the hotel? Where was the crime scene? When we say the crime scene, you mean the place where her body was found?
Right. She was shot once in the head, and police think that she
Sorry,
was just.
I didn't make myself clear.
I'm sorry. I believe, according to my memory, it's about 3.5 miles. The bar was maybe a building or two from the motel. They were right next to each other, and then the crime scene was about 3.5 miles away, going back toward Vero Beach on State Road 60. So 3.5 miles.
In continuing on, I think what you didn't yet mention is, what did McComb have to say in this case?
McCoon, in this case, testified that Wyatt admitted shooting her and admitted that he was going to have sex with her but decided not to, and that he took her out and shot her just to see her die, and that she was a nobody, she was just a barfly. In terms of the information that McCombs knew that he couldn't have gotten from the police reports and, you know, the extradition things, he knew that Wyatt had been playing a stuffed animal crane game with her. That was in his testimony. He knew how she had been killed and the injuries. The top of her head had been blown off, as opposed to just being shot in the head or somewhere else. He also knew where the body was. He said that it was near a canal off of State Road 60, back toward Yeehaw Junction. And he, again, knew about Fast Eddie because Wyatt said that he'd gotten a cab ride from someone named Fast Eddie. And again, in this trial, the state again brought in Eddie Pugh to testify that he picked up Wyatt, and his nickname was Fast Eddie. So McCombs knew those, that...
Did he testify at all about how Lovett was involved in this crime?
McCombs?
Yes.
No.
How was Lovett involved in the crime? What was the state's, was he tried for this case,
No.
murder too?
No. He was just tried for the Dominoes.
Lovett wasn't tried for this murder?
I don't believe so, no.
What was Lovett's, obviously Lovett was involved in some way. What was there had to be some way that his DNA was in the victim, victim.
Mr. Wyatt testified that they went off and Mr. Lovett and Ms. Neidiger were fooling around, and Lovett had sex with her, and then he fell asleep and they left. Lovett came back by himself with her car, left the car at the motel, went somewhere, and Wyatt said he didn't come back, so I just took the car and left.
So why isn't that, again, if we're looking at explanations of innocence, why isn't that a possible scenario in this case, that Wyatt really didn't have anything to do with it?
Well, it was presented to the jury. And
well, I know, but we're talking about the issue of the probability of the acquittal because of the CBLA. So you're saying that you still...
But you still have the gun, and that's a critical issue, because Wyatt had possession of the murder weapon after he separated from Lovett. If
That's
Lovett,
you mean
if
because
Lovett,
he gave it to Freddie Fox to
the pawn, yes.
That's very and that testimony hasn't been called into question, Freddie Fox's testimony?
Never. And so, the fact that Wyatt possessed the gun after the murder and gave it to someone to pawn, that links Wyatt directly to this crime. And that has nothing to do with McCombs or the bullet lead analysis. Moving on to the penalty phase, I just wanted to correct or inform the court of some factual matters. The defense attorneys, there were two of them, Ms. Liddy and Mr. Sidaway. They both went down to both North and South Carolina and interviewed witnesses themselves. and had investigators interview witnesses. Ms. Liddy testified at the evidentiary hearing in 2007 that she had 15 banker boxes of materials and reports on Wyatt's social, medical, and criminal history. And they included school histories, socioeconomic backgrounds, socioeconomic histories from his parole officer, and a myriad of psychological reports. She gave that information to Dr. Rifkin, and she testified to that at the evidentiary hearing.
What's her background, or what was her background at the time?
She was a private defense attorney.
She subsequently became a public defender?
She became the public defender in this circuit.
But that happened, that was after the...
Yes. And so she testified that not only did she collect 15 boxes of records and materials, but that she gave the relevant information to Dr. Rifkin to evaluate. In fact, that's where Dr. Rifkin got all the bad information he included in his report. Additionally, she had a neurologist appointed to examine Mr. Wyatt for possible brain damage. They didn't find anything. Before Ms. Neidiger's trial began, Ms. Liddy, actually asked the trial judge to appoint Dr. Bordini, the exact expert who testified in post-conviction, as a neuropsychologist to examine him for brain damage. The trial court denied that request, but allowed her to get an MRI, and the MRI did not show any brain damage. So Ms. Liddy and Mr. Sidaway's performance was not deficient. They did a complete workup of the mitigation, both in terms of the lay witnesses, collecting records, and consulting experts. They made a strategic decision to go with the lay witnesses because they would get out the information they needed about the alcohol and drug abuse, the abuse by the father and stepfather, as well as the sexual abuse by the teacher. And the trial judge made a finding after the 2 evidentiary hearings that the witnesses that Mr. Wyatt put on in post-conviction merely provided cumulative information, and that Mr. Wyatt cannot show prejudice because of this. And we ask the court to affirm.
I'm not sure how long I have left, but I just want to address one of the points.
About 2 minutes.
Sorry?
About 2 minutes.
Okay. Regarding Ms. Liddy's cross-examination of Agent Riley, I think it's worth noting to the court that on redirect, the state again got Mr. Riley to say, yes, this stuff is reliable, and it's the product of 25 years of research, and in his opinion, the bullet found in the victim came from the same box that Mr. Wyatt was in his possession. He didn't change his opinion at all, and in fact his opinion was relied upon very strongly by David Morgan, the prosecutor, in his closing argument.
That's the bullet, but that was the bullet analysis. How about the gun? Is it correct that the gun that Wyatt gave to Freddie Fox was linked to the murder weapon?
Well, they tried to connect the gun with the murder weapon through the bullet, and they weren't able to do that with the stippling, so that's why they had to use the CBLA.
So you're saying independently that the fact that he's in possession of the particular gun would have no evidentiary significance?
It wouldn't tie it down in the way that the CBLA purportedly did, Your Honor. And if the court has no further questions, I would ask the court to remand and refer this case for further proceedings as appropriate. Thank you.
We thank you both for your argument. The next case on our docket today is Florida Insurance Guarantee Association versus Devon Neighborhood Association.
Good morning. May it please the court. My name is Jeff Coun. I'm from Gray Robinson on behalf of the Florida Insurance Guarantee Association. We are here today to review the 4th District's opinion relating to the amendment to a statute which imposed new obligations, required the insurer or FIGA to pay for carrying out those obligations, and imposed a penalty by waiving a contractual provision if the obligation wasn't carried out, or if they carried it out but the mediation was not successful. We believe that the 4th District erred when it concluded that that statute could be retroactively applied. This court has a two-part test that has been consistently imposed to determine whether a statute can be retroactively applied. First, did the legislature intend for it to be retroactively applied? And that has to appear on the face of the actual bill. And second, can it be constitutionally applied? In this case, there is nothing on the face of the bill to indicate that it could be retroactively applied. And in fact, the statute specifically says the law will be effective upon becoming law unless otherwise indicated.
Was that argued to the trial court or to the appellate court?
Your Honor, the argument relating to retroactive application was argued. In the 4th District, the waiver issue has been raised. FIGA argued that you could not retroactively, the insurance contract at the time, the law at the time the insurance contract is entered governs, and that you could not retroactively apply a new statute without impairing.
So the issue of when this statute became effective was specifically briefed and argued. I'm not talking about whether you used, a case or not, but I'm just trying to see how the 4th District came to just ignore the first prong of this, retroactivity analysis.
Well, Your Honor, and I will certainly confirm, my memory and my notes indicate that it was argued that it could not be applied because the statute was not effective. Unfortunately, Devon did not address that in their answer brief, so nothing further was in the 4th District, so nothing further was stated. In the trial court, it was not the crux of the argument. The main part of the argument in the hearing in the trial court was it waived by action? Was the right to appraisal or the alternative dispute resolution waived by action? 4th District, the briefs, because the trial court's order simply said denied, covered every argument that was raised. With regard to this argument, it was not responded to by Devon. Therefore, the 4th District's analysis, I believe Pomponio, the case they relied upon, was not cited by FIGA in its initial brief. The argument was raised, but the site was not raised, and it certainly wasn't raised by Devon in the answer brief. So the argument was made, and I believe the effective date of the statute was included in FIGA's initial brief. The point was not addressed by Devon and therefore was not responded to that would govern, but it clearly was raised that the law in effect at the time the insurance policy is entered governs.
But was the focus of the argument below really whether this would be, and that application of this would be an impairment of contract? I thought that's what the focus had been before.
It was certainly the focus of the 4th District's opinion. The focus of the brief, and there was extensive briefing and only a very small portion discussed this statute, was first paragraph was you cannot retroactively apply it because the insurance contract is controlled by the law in place on the date it becomes effective. The second paragraph of this section was it would impair the obligation of contract, citing to, I believe, a 2nd District opinion that quoted Dewberry in this court.
Let me make sure that I understand on your argument when you say not the focus. Was the issue of retroactivity part of any motion, pleading, piece of paper that FIGA may have asserted in response or in attempting to force the appraisal? I've got to assume that this issue, something came up about the statute, didn't it, at the trial level?
Yes, Your Honor. Retroactivity was certainly raised.
And whether it could or could not be.
Correct, Your Honor.
And so I'm trying to understand, make sure that I don't know of a case that says that if you don't cite the right case, you lose, but you certainly have to preserve the argument. That's where all this is going.
And that was a point that I intended to make, that you don't have to cite a case, you have to raise an issue. That citing a case is somewhat irrelevant. You're not required.
But it can be helpful, but it's not essential.
Yeah. Well, and I guess that was the point of my statement, that it was not the focus of the
But
brief.
if I look at the record, and because I haven't looked at those pieces of paper, it's going to be somewhere in there with regard to the attempt by FIGA to force this into appraisal.
Correct, Your Honor. There is a motion that was filed in the trial court relating to appraisal and a reply after that issue was raised. It was also discussed at the hearing before the trial judge. Then before the 4th District, it was a section in the brief.
But what you're saying is the first thing happens, you try to get the appraisal. They say because you participated in the litigation, you've waived your right to appraisal. So the statute doesn't, at that point.
The focus of their argument at that point was because you participated in the litigation, you've waived your right to appraisal.
But did they raise affirmatively the statute that says that you had to provide notice?
Correct, Your Honor. They
Okay,
raised
so
that.
and there's no question that they raised the statute.
There's no question that they raised that. It was not.
Okay, and then in the trial court, did you argue that no, that statute doesn't apply
Correct, Your
because
Honor.
it's came into effect after the contract?
Correct, Your Honor. That
Correct.
was argued.
We'll see that if are there pleadings that show that?
There was a motion, a reply, and, excuse me, Your Honor, the transcript of the trial court hearing.
You understand why we're asking these questions, because you read, got an opinion by Judge Warner, and it's as if they don't, they just assume, maybe they assume it was retroactive and then go into the second prong, so that's, is that what you think does it look like that's what happened? Did they have an oral argument? Did they ask you
There was
about
not an oral argument, Your Honor, and I certainly don't want to imply that I know what Judge Warner or the panel was thinking, but because it was not an issue that was addressed in the answer brief, I assume that the portion of the initial brief is what they discussed, and the remainder of their discussion was outside of any of the briefs.
Well, it does state in the opinion that FIGA claims that it was not bound by the notice provisions of the section, and it cites the section, as the amendment which would have applied the statute to the insurance contract in this case was enacted after the policy went into effect.
Correct, Your Honor. That was argued to the trial court and the 4th District.
Was there any discussion ever in this case anywhere that this whole appraisal issue is totally illusory? I mean, here we've got an appraisal provision. If I'm reading the policy correct, it's that the insurance company can force an appraisal, but they still can refuse the claim.
Your Honor, well, that's not an issue before the court. It has been an issue before the court, and the court reached the opposite conclusion in 1996 in State Farm v. Lucia, and again, it's not before the court, and it's therefore not in the briefs.
Well, it's part of this case. That's the clause in this case, and this case is about whether we're going to force appraisal, is it not?
Correct, Your Honor, it is, and if you would like supplemental briefing on that issue.
No,
but
I just asked the question.
It has been considered and determined that it is not illusory. The court in 96 did, subsequently in 2000, reached the same.
But that is what, in fact, the policy provides. You agree that it's like they get this appraisal, go through the whole thing, and then they can say, nope, go on trial.
I would agree in part. The courts have held that absent certain circumstances, the appraisal provision would be controlling as to the amount of loss. Whether there's coverage is a different issue. There was a 2nd District opinion written by Justice Kennedy, and more recently a 4th District opinion, that coverage is an issue that's always for the courts, relying, of course, on this court's authority. The amount of loss, absent certain circumstances, mistake, fraud, error, things of that nature, would be controlling as to the amount of loss, which is what the policy provision says. And that is what the appraisal.
Well, it doesn't say that clearly. No, not as clearly as you would. And I understand you didn't write it. You've got to deal with what you have. So please go ahead. I don't want to belabor that kind of point. So
we believe it was definitely raised. The section stated that it would be effective after the remainder of the legislation. And we believe that it imposed substantive changes and substantive policies. This court has held that when there is any impairment of contract, it is not permissible. In this case, there was the impairment by requiring affirmative action, or this policy provision would not be enforceable. Additionally, there was this court's Dewberry case said, any conduct on the part of the legislature. And we certainly believe that would be any conduct by forcing an insurance company or FIGA after a carrier goes insolvent to take that conduct.
How do you, in terms of the test that is applied, Dewberry came out, I think, a year before Pompiano, and until last week, we hadn't cited Pompiano for about 25 years. I guess this must be one of Mr. Rosenbaum's favorite cases. But what are the two, how do those cases mesh together in terms of what should be applied under what circumstances? And then where does Menendez fit in?
My interpretation of the court's various opinions is that there are two parts, and the impairment of contracts test would fit into the second part of the test. Is it constitutional? And in this case, the constitutionality has been challenged on the impairment of contracts basis. The first part of the test still applies, and even the police powers case that was cited by Devon in this case, while the legislature does have the power to regulate insurance, I believe it was the Springer case, that court recognized that because the legislature in that case hadn't intended a retroactive application, it wouldn't apply.
So, right, if we agree with you that this was not intended by the legislature to be retroactive, there's nothing else that needs to be discussed.
Correct, Your Honor. I believe if you agree with that, there's nothing else to be discussed. It was stated in the answer brief that we are asking the court to overrule Pomponio, and I don't believe that's what's happened here.
So what would happen? If we say, in fact, that this statute does not apply retroactively, we would go back to the trial court and you would again ask for an appraisal, and you would be entitled to the appraisal under the insurance contract. And then,
Correct,
and then we get to the point of whether you abide by it or not.
And at that point, there's a district conflict, but the court could either send it to appraisal and proceed with coverage challenges, or stay the case pending the completion of the appraisal. That's something that the court will be deciding soon. But
what issue?
Whether the case will be stayed to allow the appraisal, or whether the appraisal will proceed on the amount of loss while the trial court determines.
Is that's a conflict between the districts?
Yes, Your Honor. I don't know if someone has brought it to the court, but it has been certified recently by the 3rd District.
In what case?
Your Honor, I apologize.
But it's not an issue.
It's not an issue in this case,
Okay.
certainly.
Yeah.
This is we believe this is a simple analysis, as it was in the old Port Cove case, also Mr. Rosenbaum's case, with Justice Quintero's opinion a couple of years ago. It can stop after the first prong. There was no retroactive intent. In fact, we believe there is the exact opposite. But if it does proceed to the Pomponio or the impairment analysis, we believe it would fail there as well, due to these obligations.
Again, did you explain why, if we had to get to the second prong, what the next inquiry is?
The next inquiry would be, does it actually impair the contract?
So if there's an impairment, then you don't get to, then when do you use Pompiano?
If there is an impairment, there would be the Constitution would prohibit it. Pomponio provides the test to determine if it is a reasonable subjective impairment of the contract. We believe that the court has held that when there is an impairment such as this, a subjective impairment, not something that is mere procedure, which this is not. This is a substantive obligation imposed.
You said subjective impairment. You don't mean subjective. Do you mean subjective impairment?
Substantive impairment.
Okay.
I apologize, Your Honor. This is a substantive impairment of the contract. It requires action. It imposes penalty. It requires the insurer or FIGA to pay for a mediation. And those are substantive issues that are more method or procedure, which is what would fall out of the impairment test. If it was a procedural issue, the case law indicates it would not be.
Under the statute, and let's just indulge me for a moment that the mediation provision would apply. And once you go through that, then are you still entitled to appraisal if you want to?
If
one of the parties would,
that the mediation
if
applies,
mediation fails, you can still ask for
that is
appraisal?
Not the statute. If the insurer requests the mediation after the notice is given, and the mediation is unsuccessful, the statute also provides for a waiver of the appraisal provision. So even if you do comply with a notice, but you ask for the mediation and you go, and it's not successful, it's also waived.
So this is, in terms of the importance of this to insureds, this provision, it's a method to escape from what I guess the legislature thought was an onerous provision in the contract, the appraisal provision?
Yes, Your Honor.
So this is this example of the legislature doing something that was to help the insureds escape from a provision that would otherwise be costly and time-consuming.
Presumably, that's correct. Your
Well, I
Honor.
mean, that's what makes it substantive, because this is a part of the insurance policy that they're now saying really it can be avoided.
Correct, Your Honor. They are allowing it to be avoided in
They're
multiple
really
different ways.
rewriting the policy.
Correct, Your Honor. They're,
Let me make sure I understand what you said, because I thought the way the statute read is that if you give the notice and there's mediation, you could still have appraisal. But if you don't give the notice, that's when you cannot, the insurer does not have to go through the appraisal process. That's not correct?
that is correct, Your Honor, with the exception that it also says if the insurer requests the mediation and you go and aren't successful, that is also a waiver of the right to appraisal. So your statement was correct with the exception of when the insurer...
So the statute actually does away with appraisal?
It does away with appraisal unless if notice is provided and the insured requests mediation, or if no one requests mediation, then appraisal would still exist. It's only if the insurer, the insurance company, is the one that requests the mediation and you go and are unsuccessful. That is the second instance when appraisal is waived. However, if no one...
But if the insurer requests mediation, then the insurer will still be in arbitration.
Make sure I understood correctly. If the insured requests it, yes, Your Honor. If the insured requests it and it was...
The insured requests mediation, not successful, and FIGA will still be entitled to go in and ask for the arbitration or the, what do you call it? The
Appraisal, Your Honor.
Appraisal. Call it what it is, an arbitration, binding.
Calling it arbitration and appraisal is only troublesome because the court has held that they are different.
Okay, well, whatever, but that the only when the insured requests mediation and is not successful do they waive the
The right to
appraisal.
appraisal. Yes, Your Honor.
Well, so why isn't the imposition of another step, mediation, why isn't that just procedural? I mean, we just required in mortgage cases for mortgage holders to go through pre-suit, post-suit mediation. Mediation is a regularly accepted way of doing business. Why isn't that just a procedural step, not substantive?
I think for a couple of reasons. One, when the court exercised its constitutional right to impose a procedural requirement after a suit was filed, I think that is different than the legislature imposing upon the insurance industry the requirement to have a mediation program that's funded by the insurance industry. And if they do not give this notice within 5 days of the claim or the dispute, they're not entitled to enforce that contractual provision. There's nothing when the court required mortgage companies or lenders to go to mediation, there was no waiver of any right. It was merely we are requiring you to attempt to settle this claim with a non-party independent person to try to settle it. However, if it's unsuccessful, then you will proceed with litigation and the trial court judge will make a determination.
You're just about out of time here. I'll still give you a minute to close.
Thank you, Your Honor.
May it please the court, Dan Rosenbaum here on behalf of Rosenbaum, Mullen Garden, Jansen, and Syracuse, and West Palm Beach for Devon. And I'd like to, if I can, start out by answering Justice Parente's question about the different standards, because what occurred in this case and why Pomponio is so important is in 1978, the United States Supreme Court adopted a case called Allied Structural Steel. And there's a whole federal history that went to the Contracts Clause analysis. In 1979, this court came out with Pomponio versus Claridge, which said that when we look at contract clause issues, we're going to go ahead and use the United States Supreme Court standard from Allied Structural Steel. Now that standard is different than the two-prong test. So when we look at contracts clause issues, the first question is how damaged, if you will, what's the impairment to the contract? And then we get into the balancing test to see at what point we have damaged the contract so badly that it's unconstitutional.
Well, don't you first, though, have to decide whether, and maybe this is how you argued it in the 4th District, don't you first have to decide whether the legislature intended, for whatever statute they're enacting, for it to be retroactive?
Not under Pomponio and not under Allied Steel. That test, the two-prong test, is tests that we historically have used.
Let's just, I'll look back at those cases, but I don't know of any analysis of legislation that doesn't start with what the legislative intent is. And if the legislature doesn't intend for a provision to apply retroactively, then they're not even affecting the contract that was in existence. So you don't get to whether there's an impairment of contract if the legislature did not intend for that provision to apply.
Well, when we're talking about impairment of contract, it's presumed that there's some level of impairment. In other words, the legislation...
I think you're missing my point. The legislature makes a decision when they enact a statute. It's going to apply prospectively. It's going to apply retroactively. That's the first issue. Do they intend for, like in your case, the Lacone case, it was clear that the legislature intended for that to affect condominium documents. We didn't need to go to look at the first test because it was clear the legislature in that case made it retroactive. They said so. So I'm not buying your idea that we somehow don't first look at the legislative intent.
And the thing is, we have said in the past in this court that when the legislature includes the effective date of the statute, that we give that inclusion, basically it effectively rebuts any arguments that is not retroactive. Here they included the effective date as being July 1, 2005. And the problem I have with your argument is that, let's say you and I entered into a contract a year ago, and the legislature, for all we know, could be contemplating a statute right now as we speak that would benefit you tremendously in that contract. And unless that's the problem I have with the Pomponio component that you're arguing.
It's like the Bionetics case, Justice Labarga, that you authored. In the question there in Bionetics was when the harm occurred.
Right.
In other words, you have safe harbor, and your decision turned on when the harm occurred because you went with the 1st District in Walker, I believe, and not with the 5th District's opinion. That's the same thing here. The statute
wait a minute. That's the question of which law applies, and we've held that the law at the time of the execution of the contract,
right,
not at the time of harm.
Well, in Bionetics, you see, this is the difference that I see in the case law. When we look at the cases that have come up, and Justice Parenti mentioned Mendez, okay, or even Old Port Cove, these were not impairment of contract cases. These are cases, for example, in Mendez, when we're talking about whether what someone's rights are under a statute, or Old Port Cove, similarly, or Metro-Dade County. Again, should someone be forced to pay for a cleanup? Or Bionetics, with regard to safe harbor. These are not impairment of contract cases. These are cases in the law where there's a statutory scheme that someone is either under or not under. That's where the two-part test has been utilized. The question in all those cases...
This is a contract case.
That's right, and that's why Pomponio applies to this case.
You're going in circles in my mind. I'm trying to follow you. I really am. But you've lost me here.
The 4th District applied Pomponio, and
Well,
they
I
didn't look at the
understand.
two-part test. Now, in talking about, as we did before, whether the issue was raised, what we said in our brief was they never raised the test. In other words, they never cited to Old Port Cove, and they never cited to Metro-Dade. That came up on rehearing. Mendez obviously hadn't issued at that point. So that was what we're saying. We're saying you never had brought up the two-pronged test. In the 4th District, what they argued was the flip side of Pomponio. They just said Pomponio would apply and it would apply the other way. So the 4th District looked at all these different positions, looked at all the different issues, and determined the contract had not been sufficiently diminished or impaired to take away a right. Why? Because it's not so much, it's not only the question of appraisal, which when you have an appraisal, the insurer is still permitted to raise coverage defenses after the damage determination.
What is the statement in the 4th District opinion that says FIGA claims it is not bound by the notice provisions as the amendment which would have been applied to the statute, to the contract in this case, was enacted after the policy went into effect? It sure sounds like they're raising, nope, you do not apply this statute because it went into effect after the policy was executed.
But if you look at the last paragraph, what they're saying is, and this is the way subsection 7 of the statute reads, it says you can't raise appraisal as a precondition to litigation, to go into court. Here, what was happening was the insurer, FIGA, tried to use appraisal to stop the insured from going to court. Now, appraisal itself in the process, you have the determination of damages in the appraisal process, but the insurer always has the right under this policy to either accept it or reject it, and even if they accepted the appraisal, which is the determination of damages, they still have the right to go to court and determine coverage issues. So all this statute really does is saying, look, we just had 4 hurricanes in Florida. Okay, we had Gene, Ivan, Francis, Charlie. And now we're in 2005, and precipitously we had Wilma. So the courts were overloaded. What was happening to insurers was that they couldn't get their claims adjusted because there was tens of thousands of them. So they wanted to put mediation in process so we could get rid of some of these cases. Now what they're saying is the carriers, if you're not going to give this notice, then you lose your right to raise the appraisal process as a precondition to the insured going to court. In other words, we're not going to make the insured...
Well, but you lose it totally. I mean, that's like saying it's not that it revives itself again afterwards. Appraisal's gone.
It's not gone because the insured can always agree to it. In other words, the insurer can't...
No. You're talking past me again. If you don't do an appraisal and you take your damages to court, your breach of contract action to court, are you saying that this allows the insurance company to come in again later and raise the appraisal?
Not later, but...
No, you can't. And that this clause terminates an insurance company's rights to an appraisal if they don't follow the statute.
Well, the statute says precondition to going to court. So if the insured... let me give you an example if I can. Maybe this will help. If the insured, let's say there was no notice given and the insurance company invokes appraisal, there's nothing to stop the insured from agreeing to the appraisal and just going forward without raising this issue.
It's the insurance company. That's what we're talking. The insurance company's right to follow the contract and the right of appraisal. If they don't follow the statute, this statute eliminates, because it then eliminates that as a precondition for a legal action, and the right to appraisal is gone.
Unless the insured agrees, correct.
Okay, well, that's all I'm saying, is that it eliminates that right.
That's correct.
Forever.
That's correct.
Okay.
So why isn't that a core substantive right that cannot be retroactively applied?
Because, number one, the statute's remedial. It's not per se affecting the right.
Well, you just went through with Justice Lewis how it is an elimination of a right.
Well, what I'm saying with Justice Lewis, the question here is under Pomponio, the question of the amount of diminution to the contract. What's the damage to the contract?
That has to do whether it's constitutional. There's a constitutional impairment of contracts or not. What we're struggling with here is whether it's retroactive in the first place. And I've yet to hear you say why it should be.
Well, the reason it should be retroactive is, number one, it's procedural in due respect, in most of the respect, and to the extent that it could be argued that it's substantive, it's remedial. So those statutes don't come within the court's ambit of being unconstitutional if they're remedial.
That is, but you're real. Listen, I have read a lot of cases and written cases. This remedial issue, if it's substantive, the fact that it's remedial doesn't make it any less proper for the legislature to make it retroactive if there's an existing right that has been diminished.
But that kind of gets me right back to where I started. The test that this court adopted in 1979, which makes good sense because it follows the United States Supreme Court test, is the question of the diminution to the contract. That's the first prong of Pomponio.
Well, are you telling me why is this not under Dewberry, Menendez, those other cases?
And what I'm suggesting is when we read those cases don't attach to the way we analyze contracts. Those cases have applied historically a two-pronged test, but they've not been contract clause cases.
Menendez didn't involve an insurance contract?
Menendez was the PIP statute, so there wasn't a contract. It was
sure there is. PIP's based on a contract.
Well, PIP eliminated the common law. In other words,
but it's in a contract. It's just not out of the air. An insured has a contract for personal injury protection benefits, PIP, and then the legislature attempted to change what was in that policy.
Right.
And we said, no, you can't do that after the policy is issued. Correct?
Well,
so that's
yes,
a contract case.
Well,
that was a statute operating on a contract. Correct?
I believe that it's a contract that was different here because it replaced the common law. In other words, PIP was there to give instant money.
Well, I mean, this appraisal that's something that's not part of a right under common law. It's a contractual right.
Right. It's a contractual. It's a purely contractual.
And PIP comes from a contractual right because we now have that coverage under Florida law.
But historically, if you look at these cases, and I went back to check how these cases came about, these have been the two standards, and maybe that's why the jurisdictional question was 4-3, because this is not a clearly defined area of the law. This is a difficult area of the law to understand how you reconcile these two tests. How I reconcile them is going back and looking at how they historically came to be.
But let's just go back to this, and I think that you may be just trying to escape the first issue. In Pompiano, the question, I look back at it, but I don't know of any analysis that doesn't start with, and I hate to go back to this, but I just want to, Justice Lewis, Justice Labarge asked you about this, that doesn't start with whether the legislature intended the statute to affect contracts that were previously in effect. That anything that the legislature do has to start with that question.
Well, I answer that.
Do you agree with that?
I agree with that to the extent that the harm, if you look at the harm, and the contract
not
itself,
any extent. It starts with, if this legislature here had said, and this will only affect contracts that are signed after February 1st. Let's just say they put that in. Would you then say, no, you still don't look at that. You still look at whether it's impaired the contract to a significant extent?
I think the question of impairment, just to answer your question, Justice Parenti, if you look at retroactivity, okay, everything, if we only look at the laws at the time the contract was made, we can, for example, if we had a problem like Japan has right now, and somebody had a dairy contract to provide milk in an affected area, under that analysis, we could never stop the milk from going.
No, that's not true at all. It's not. That's not a good analogy. You have all kinds of acts of God and other things that may occur that interrupt a contract. But that's not what we're talking about here.
But if we had a similar situation, I just use that because it's one that's in the news. But if we have a similar situation, impairment of contract is not complete. It's not a total devastation. If you have the laws that are in effect at the time of the contract, we know there's going to be subsequent laws that can be passed. The question is,
but you haven't answered my question. Is the legislature then, if it's the legislature of Japan and they operate like we do, would say, and this is going to affect, they put into effect under their police power some catastrophic decisions. the question, what you're saying is, well, that's what the legislature must have done because they had all these hurricanes going on. They must have intended that this be applied retroactively.
To the harm that occurs, therefore, to that extent, it's retroactive.
But you would have to have legislative intent. They intended that. That's all I'm saying, and I thought we were all saying that.
I think I agree with that to the extent the harm occurs under the contract later. In other words, I equate this more with the Bionetics case in terms of the analysis of this court on that provision under 57105, the safe harbor provision. Because
if the harm occurs later, then maybe it's more likely the legislature intends it to apply retroactively, but that doesn't still dispense with the first part of the analysis. What did the legislature intend?
Well, the intent, I think, is set forth in the statute, and I think the intent was that if there's going to be a hurricane or damage that would come under a property policy after the effective date of July 1, then it would be subject to the mediation notice that's required. You're supposed to give notice of that. And that's when the policy kicks in. There has to be a damage.
And so you're again, so that's really the first time, I think, answering the first question, which is the legislature must have intended it to apply to anything where the damage occurred after the
Yes,
date.
because that's when the notice is given.
But that's, that is still a statutory construction analysis.
Well, you see, the thing is, I think we look at all these different cases, and if you try to reconcile the two-prong analysis with Pomponio, which is from the United States Supreme Court, effectively, the two of them don't perfectly mesh. And that's because one starts out by saying, is it retroactive? And then if so, is it constitutional? The other one starts out by saying, look at the contract. Is the contract damaged, substantially impaired? And then we balance out the state's interest versus the contractual
I guess
interest.
I'm never going to, but I will look at the U.S. Supreme Court case, but I can't believe they don't start with the question, did the legislature intend that this impair the contract? Is that
Let's
the
take
first?
that as a given.
Of course, it has to be.
Yeah.
It has to start that way.
Let's take it as a given. I'm looking at this particular statute, which only implicates when there's harm, because otherwise there's no reason to give the notice if there's no harm. So let's say it's retroactive. Okay, that takes us. If you go to the two-part test, what happens is the next question is it constitutional? If you go to Pomponio, the question is, how badly did it damage the contract? And if it damaged the contract badly, we look at these 5 or 3 or 4 factors.
But it still seems to me that, after saying all of that, I haven't heard anything that says what language in this statute we can look at and say the legislature intended this to apply retroactively. What is the language in this statute? Because otherwise, we would be pulling it out of thin air.
The language that they used specifically was a procedural device, and it's in the brief. I'll try to find it as we're speaking. But there's a procedural device that was being imposed of mediation, pre-suit mediation, to avoid the costly appraisal and costly court processes that were then ongoing. So what they were trying to do was to encourage the insurance companies to give notice. They mandated the giving of notice specifically to the insureds, so we could avoid getting into a situation where there is a process that they can come into in which there's no intimidation or coercion or expense.
Okay, so you're telling us that the use of the word procedural in this statute is what tells us that the legislature intended this to apply retroactively.
Well, they went through it repeatedly, that this was a procedural device. They had the date specific as to when the statute would take effect, which was July 1 of 2005. They talked about it, and here's the language. It's on page 20 of our answer brief. It provides an alternative procedure for resolution of disputed property insurance claims. And under purpose and scope, it said that the statute sets forth a non-adversarial alternative dispute resolution procedure for a mediated claim resolution conference prompted by the need for the effective, fair, timely handling of property insurance claims. It says the purpose of the procedure set forth in the statute is to bring the parties together for a mediated claims settlement conference without any of the trappings or drawbacks of an adversarial process, to encourage the insureds and insurers to resolve claims as quickly as possible before resorting to these procedures. And the preamble to the law enacting the provision that's at issue here states that the statute is being amended to revise the purpose and scope provisions relating to an alternative procedure for resolution of disputed property insurance claims, providing that failure of an insurer to notify a claimant of the availability of the mediation excuses an insured for being required to submit to certain loss appraisal procedures, processes. That's basically page 20 and 21 of our brief.
You have now exceeded your time. I'll give you 30 seconds to sum up.
Thank you, Justice Kennedy. I apologize for exceeding the time. What I'm trying to just focus the court on is that these two tests are out there. One specifically historically applies to impairment of contract. It assumes retroactivity. The other one, it does not involve contract historically. There may be some crossover in occasional cases where it did, but that test, that two-pronged test, says is it retroactive, and then we get to the question of is it constitutional, and that's where we're kind of left with a blind eye. Thank you very much. I just ask the court to affirm the 4th District's thoughtful opinion.
No, I have limited time, so I'll be brief. To the extent Pomponio did not discuss retroactivity, it's because the court had decided 1 year earlier, discussing the same statute, that it was intended to be applied retroactively in Century Village v. Wellington, and that was included in a footnote in Justice England's decision that retroactivity had already been discussed in the prior opinion.
How about counsel's position that you read the statute thoroughly, and virtually every sentence contains procedure, procedural, procedure, procedure, a procedure to eliminate, a procedure to do thus and so?
I'd say a couple things. One, with all due respect to the legislature, the labels they ascribe to something cannot be taken as the answer. They could get around every impairment of contract test or question by the courts if they simply described it or labeled it as a procedural device.
If it hadn't touched upon the appraisal, would this apply retroactively?
If there was no penalty, if they were just required to...
No, they did not. The appraisal wasn't mentioned.
They just required insurers to go to mediation? It's a difficult answer. I mean, there still are the issues of the payment, because the insurer is required to fund the mediation program. But I believe that... I thought it said that when it talks... Oh, the mediation. Okay, I'm sorry. Yeah. So I think that would be a more difficult test, but that's not what's before us.
But it does seem, you're out of your time, but I think the best point that was made is that this statute was enacted in the wake of these hurricanes, and isn't it then pretty clear that the legislature was wanting to deal with an immediate crisis, which was the thousands of claims brought about, or hundreds of thousands of claims brought about by the hurricanes. So wouldn't it be logical that they intended it to apply as of that date to the claims being made as of that date?
I think the legislature is presumed to know this court's opinions, and this court has said that if the legislature wants it to be retroactively applied, they need to specifically state so in the face of the actual bill. And they did not do so. They, in fact, had it effective after the remainder of the bill. So we'd ask the court to reverse or quash the 4th District's opinion. Thank you.
All right, we thank both of you for your arguments. That concludes today's docket.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.